Physicians are trained in the art of medicine, science, and healing. We call this the practice of medicine. But healthcare is a business. SMA's Business of Medicine podcast is designed to educate physicians on a wide range of business topics with the purpose of empowering physicians with the business knowledge they need to better enjoy the practice of medicine. This podcast is sponsored by SMA Services. SMA Services is a wholly owned subsidiary of the Southern Medical Association, founded in 1984 to address the business and financial needs of physicians. In this podcast, James Richardson and Ric Poirier will discuss medical malpractice claims and insurance. They will provide an examination of state caps and changes, as well as statistical information for different specialties and examples of claim payouts. In addition, they will detail how malpractice attorneys and carriers will handle COVID-19 malpractice lawsuits. And will also explore how these items tie into individual personal med mal policies. James Richardson is a certified insurance counselor with IUL Risk Solutions. James is the administrator of the SMA Medical Malpractice Insurance Program. He has been in the insurance industry since 2003. Ric Poirier is a partner at Blue Williams Law Firm in New Orleans. One of his specialties is medical malpractice defense. So gentlemen, thank you for joining us today. So you've made my job easy by providing 3 key topics. Let's start off by talking about caps. Most people understand what a cap is, but tell our audience what they need to look out for when considering a policy.
Well, I'll start, Randy. This is James, and I've just to get the audience where we're coming from on this. I am in the insurance business, so I'm going to kind of be looking at it through the glasses of an underwriter, an actuary, someone who is putting policies together and that type of thing. So when we're talking about med mal as a whole, and we're talking about purchasing med mal insurance and reasons for premiums, things like that, those are often the things that come up. And it's just like your insurance that you have for your family. Me, as a pretty lame 45-year-old that doesn't really go out, I'm an easier person to insure on auto coverage than my 16-year-old who ran into somebody in her first week at high school a few months ago. So obviously those are underwriting decisions, and you charge more premium for underwriting decisions. So that's one of the things we wanted to talk about with the cap, is how the cap filters down to underwriting on a state-by-state level, because you have doctors in all 50 states. So I have Ric here with me, and we can kind of dive into the topic, but it's constitutionality of the cap. And Ric, being an attorney, sees it all the time as different states have lawsuits that come forward to try to, quote unquote, bust the cap. I pulled an article, 39 states still have malpractice caps. 8 of the states have been able to declare them unconstitutional, and then there are a bunch of hybrids in between. So I'll let Ric talk a little bit about the cap from a functional standpoint, where it came from, what the thinking is on it, and how that litigation is proceeding.
I think to better, more pointedly address your question, Randy, about what they should look out in the cap, any state that has a cap has, I shouldn't say any, most states that have caps have a 2-tiered cap. There's a cap on what any individual healthcare provider would pay, and then there's an overlaying cap that is typically funded by a quasi-governmental entity. So when you're in a state with a cap as a healthcare professional and you're looking for insurance, you have to pay your insurance for your portion of the cap, but you also have to pay a surcharge above and beyond your actual policy premium to be qualified under the cap administered by the quasi-governmental agency. So the underwriting process that James talked about happens at both levels. It happens for him in his policy placement and his underwriters for the carriers, but it also happens at the quasi-state level to assess the surcharge. And in the medical profession, obstetricians and neurosurgeons are James's 16-year-old daughter. They're going to get a bigger hit than James, who's a dermatologist or a pathologist. And it's the cost of doing business. Now, there's no surprise that the levels of income generated by the obstetricians and the neurosurgeons tend to be higher than those with the dermatologists and the pathologists. But that's sort of the reason for both scales, I think.
And Randy, I found a study, it was from 2009, but it had interesting numbers where they had examined the cap in Texas and what the cap had done. And the non-economic cap affects 47% of jury awards and reduces them by a mean of 73%. So that's what I'm talking about when you have the underwriter glasses on and you're comparing the specialty in this state with the specialty in another state, is that jury award, that verdict is going to be different state to state. So what state you're practicing in has a lot to do with what your premium is going to be.
And I guess I'd probably jump in at this point too and say, how frequently do those torts or those regulations change?
You know, it's pretty fluid, and you have, it depends on the political cycle. The more conservative legislators and governors in the various states are obviously pushing tort reform. The other side and many people in the middle question whether tort reform really works. I think the answer to that is sometimes. The cap in Louisiana was clearly in an effort, and the whole driving force, the legislative history shows you, it's put in place because the prevailing thought in 1975, when the cap and the act was passed, was that all of our good doctors were leaving Louisiana because they couldn't afford to practice here because they were being sued out of their profession. That may or may not have been true. The reasoning behind most caps, we were patterned in Louisiana off of Indiana, which, you know, I think if you read their legislative history, you could just insert different names and it would be the same testimony. Was that the sky is falling? To some extent. Has it slowed down cases in Louisiana because of the cap? I think probably not.
One of the lowest in the country is California. And if you do a quick search on California, they're at 250,000, and they are constantly having that brought up and litigating it. And it's stood up, but right now there are 2 cases pending where that could change at any time. And what as I go through the news accounts, the media accounts from it, you see some wording that's the same in all of these, and it all goes back to the plaintiff's note that the law was enacted when Gerald Ford was president, and that the value of a $250,000 award is worth $25,000 to $55,000 today. So a lot of the states with caps where you see lawsuits being brought to try to bust the cap are going back to this number was enacted in the 70s. It's not germane to what needs to be awarded today. And that's usually the basis that they try to make the change with.
And keep in mind too, Randy, each individual state that the lawyers challenge the constitutionality of a cap or of a tort reform act, it's challenged under the individual state's constitution, not the federal constitution. So that's why you get some states that say it is constitutional and some states say it's not. It's not reasonable minds differing on the federal constitution. It's the individual tenets of the state constitutions.
Okay, so this sort of begs the question from a provider, is it realistic or to assume that every time your state flips, you should have your policy looked at?
Yes. Yes, which is why, but I mean, obviously it wouldn't be a retroactive because that would be probably another constitutional taking. But
Sure.
there certainly is that. Now, you've got every hospital and physician healthcare provider lobby in every state pushing to keep things either status quo or even more conservative. And you've got the competing forces. So you're always going to have it. And that's one of the reasons. I can tell you in Louisiana, every other year in the state legislature, they have to address things that are not simply budgetary issues. And I think since 1970, is it the even number of years we do budgets?
Mm-hmm.
So every odd year since 1975, there has been at least one, if not a half dozen bills on the floor of the legislature to make some change or another to the Louisiana Medical Malpractice Act, which institutes the cap. Some are just, growing with the times on how to accomplish things, but others are trying to increase the cap. And, it hadn't happened.
I think that's sort of, is our role is, sort of an advocate for the provider, is that this is probably not something that you leave in place as is for a decade. That your policy and what you're getting with regards to service and product is something that needs to be looked at probably more frequently.
Well, you know how I always put it into perspective when I'm talking to a physician client, especially a neurosurgeon or an orthopedic surgeon, and we're on a discussion about how the cap is or isn't fair. I ask them, if you were the victim of malpractice at age 40 with tens of millions of dollars of earning power ahead of you, and you lost all that, do you think it would be fair to you and your family that you were relegated to $500,000 plus medicals? Boy, and their answer, they don't even have to think about it, is absolutely not. Like, yeah, well, what's good for the goose is good for the gander. And you have to think about that. Now, that's the extreme, but it makes you wonder whether or not it is due to be addressed.
But also, I pulled several sites I found that go in depth into each state, and it's all over the board. I mean, there are hard caps, there are loose caps, there's no cap by legislation, there's no cap by a judicial decision, there's everything. One that's interesting is Maryland. It said that they started in 2005, they went to 650, and they increased by $15,000 a year. So they put that inflation guard, as we would say in the insurance industry, in there. So that's something that could be a trend that you see move forward in states where they can take care of it through legislative action without this constant going to the courts to try to bust the cap, bust the cap, bust the cap.
You also see in every state, because of the differences in how the caps are structured, some caps aren't even attacked for constitutionality because the system in and of itself allows for either exceptions or a lighter standard of care. Texas is a prime example because we get compared as a Texas neighbor here in Louisiana. My physicians say, well, why are claims going down in Texas and not here? They've got a lower cap than we do. Well, because at the time they passed the cap, they also did a more aggressive tort reform and required a bunch of hurdles to be cleared before you can even file the claim. So not only is there a cap on some things, you've got to jump through hoops to even file the claim and get it heard. Which it's real easy to get a claim heard in Louisiana. We just have a more stringent cap.
So let's get into everyone's favorite area of MedMal, claims. So share with our audience your claims experience, specifically as it relates to different states and medical specialties. Also tell our audience why it's important to know the specifics in these areas when considering a MedMal policy.
Well, from the insurance standpoint, it's going to follow closely with what Rick does, which is how these cases play out. And you have two things that are out there with any type of insurance, but it's true for MedMal as well, which is you have frequency and you have severity. So you have different specialties where you're going to have frequent, small, misdiagnosis or whatever the case might be. And then you have the very severe, where if one misstep can make a huge difference in a patient outcome. So with those two things at play, you have to kind of look at the numbers. Who has the most cases being brought up against them? Who has the most judgments? Who has the highest in payout, in what the final verdict is and what the number is there. So as you look through what we had pulled to go, I mean, everything is fairly consistent. You have hospitals, emergency, nursing home, OBGYN, and general surgery, top 5 when it comes to number of claims filed. And that's going to be kind of consistent as you go through what the payouts are on those. Hospitals, and you also, as with every insurance, if you think about it, go into trial, put the human element into it of what a jury may see on who's a sympathetic defendant in a trial. And if you have big bad hospital, that's different. So than individual doctor who may be there and you know had a bad day or is falsely accused of having a bad day. That human element comes into it all the time. But you can look through here and you see the ones that have that severity issue where the payouts are so high, and OBGYN, nursing home, general surgeon, neurology, orthopedic. So those are the ones that, yeah, they have a frequency issue, but mostly they have that severity issue in that if they have the claim, that claim is going to pay out at whatever the maximum is for that, because in front of a jury, the plaintiff can show that what a detriment this has been to what they're doing in their life.
Yeah, so when you're dealing with frequency, it's a little misleading when you see hospital up at the top, because in our world today, there are so many hospital and healthcare organizations that employ the various specialty physicians. And the plaintiffs have figured out that when you go against an individual physician, number one, they take it personally, so they dig in and defend like their life depends on it because they think it does. And that number two, even though they might consider a settlement, one of their biggest impediments to considering it on the healthcare provider standpoint is the National Practitioner Data Bank. Nobody wants to be reported. They think that, especially docs who've been practicing for a good number of years, you know, they've never had a report to the data bank, and by golly, they're not going to get one, so they're not going to consent to settle. When they're employed by an organization or a hospital, in many states, you'll see the plaintiffs name the hospital even though they don't have any discrete allegations against the hospital per se or the nursing staff, because a hospital can't commit malpractice, only its employees can. So they'll just name the organization, and then if they think they can get enough leverage, the doc will then press them to settle on behalf of the hospital, and he doesn't get reported or she doesn't get reported. But really the nature of the claim is against the physician. So you see a lot of claims, you know, it's the number one on the list here in Louisiana. And the second under corporation, because that's, maybe it's not a facility, but maybe it's a big dialysis center who employs all of its own vascular surgeons. It's the same thing. They just name the company to try to take a little bit of the sting out and not get the defendant, individual physician, all riled up to defend them vigorously. The corporation, the hospital, might just make an economic decision to get rid of this thing, and that often happens.
But the policyholder is the provider, correct?
Well, again, it depends on whether or not they're employed by an organization or a facility, in which case many of those would be self-insured or do some sort of a captive. And, you know, when you get down to it and do the economics of it, do we want to spend 5 years and $150,000 defending this case when we can spend 100 today and make it go away without twisting my physician's nose and getting him reported.
And again, Randy, that's going to go back to state by state too.
Yep.
Cap, no cap is going to make the economics of that decision-making process totally different from one state that is not 100,000 to another state where that could be into the 7 figures.
Now let's move into the brave new world of COVID-19. How has this specter changed the way physicians should look at med-mal? How does this change claims experience, and how can physicians protect themselves?
Well, the immediate impacts have been fairly incredible from my perspective, from the insurance industry, of seeing governments, state governments especially, move as quickly as they have, whether it be through legislation, through executive order, to protect the entire medical system from what would be medical malpractice claims that might arise in the future, I guess is the best way to put it. Civil liability immunity is what I've seen it called mostly. And it was kind of a domino effect, and different states have done it to a different level of what that looks like. But basically, nurses, doctors, facilities are getting that civil liability immunity from medical malpractice claims for treating COVID patients. Even to the extent I read in New York, they even got rid of record-keeping laws. I mean, they totally put a wall between any kind of plaintiff's action and people handling COVID. And in different states, to a different effect. The biggest thing out there from a press standpoint is that facility side of it, and this might get a little bit out of what we're talking about today, but nursing homes and aging in place facilities, that's where most of your fatalities are happening, your deaths are happening because of COVID, and are they involved in that immunity? So that's going to be a big question moving forward, is when they say doctors, nurses, everybody's got that part covered. When they say facilities, what's that definition going to look like? And what's going to be the standard of care for those facilities?
Yeah, and I think what's going to actually ultimately filter down is it's not going to be a total immunity. It's going to be an immunity from any general negligence. But to the extent you're grossly negligent, for instance, if you've got a small instant care facility and you remain open, but you don't have any hand sanitizer in the lobby, and your receptionist is sitting there without a mask on, no gloves on, and doesn't have any available for the patients, that could be a problem. That's probably close to grossly negligent in today's world. Whether or not it would have changed anything, who knows? And how do they prove they got it from her or she got it from one of the patients? You can't. But that's why I think that common sense is at some point going to ease back into that system and temper those knee-jerk reactions of total immunity.
Right. I think a lot of that came into play probably about a month ago, when everybody was still looking at the projections and saying, wow, these hospitals are just going to be madhouses for the next quarter, and they're not going to be able to sleep, they're not going to be able to eat. Some places it played out that way, other places it's business as usual. So I think they got out in front of it, which was a good thing, to make sure that all your medical professionals are bought in and going to be there. But it just didn't play out the way they thought it would from a numbers basis.
Right, and the attack on the healthcare provider is not only coming from outside, meaning their patient exposures, it's coming from inside with employee exposures and workers' comp claims.
That might be a topic for a whole
Right.
nother podcast, but yeah, workers' comp is going to be the next, I wouldn't call it a battleground, but it's going to be the next place where you see the COVID press move to, in that are you going to see legislative action or executive action in states where they say, yeah, this might not have hit what would have been a workers' comp claim, because we might not be able to say it happened at work, but we want you to cover it anyway. And then you're going to see workers' comp rates affected. You're going to see workers' comp loss histories affected, experience modifiers, all the inside baseball workers' comp stuff that goes into workers' comp claims that makes employers pay more will all come front and center.
In many cases, can't pay more.
Yeah, I think that's a whole nother ball of yarn there. Let me ask this question, because this is sort of where my head's going. How has state legislature injected themselves into the contract? What's that look like? I guess in my head, I'm thinking, well, if the legislature can just come in and essentially determine whether someone can file a claim on an existing contract between an insurer and an insured, what's that landscape look like?
Well, again, that's kind of veering outside of the medical malpractice, but it all ties in together. The biggest thing in the insurance industry that has come about from this is that you had several legislatures tee up legislation. They never voted on it, never passed it, never got it signed by governors, but to retroactively force insurance carriers to pay business interruption claims, even if they had a virus and bacteria exclusion. So that would have been changing an insurance contract retroactively, and that would have changed the complexion of the insurance industry forever, because they would have to start factoring actuarially in, yeah, it's not in my policy, but what if the government says I got to pay it? So you could see that moving into workers' comp, and then you could even see it moving into a med mal. Yeah, they gave us this protection via executive order, but XYZ happened, so they said, well, we're carving out this part of that executive order. We're going to allow people to go back and litigate that after all. It's just, insurance is a very conservative industry, and it's all about the rules. And if you try to retroactively change the rules, it makes actuaries and underwriters very nervous.
Look, I can see a COVID situation where you could be exposed and take that claim outside of malpractice, even though you're in a healthcare setting. If I'm taking my elderly mother to the emergency room and they don't have any safeguards in place and I leave with COVID, well, I'm not a patient, so I don't have a malpractice claim, but I have a general liability claim. And what's their duty? Has anybody formulated their duty? How can I say they breached the duty when we don't even know what the duty is right now? You know, prevailing wisdom seems to be some distance and some safeguards, but if they haven't had the time or the resources to put them up, how can they have breached it?
Yeah, I guess that's where my head went, as you've injected. Well, the scope is starting to fade or expand from the government standpoint, because now they're injecting rules and things into a policy and a contract that didn't exist. And how do you write contracts in the future for those types of considerations? So yeah, I didn't want to open up, like I said, another ball of yarn here, but or can of worms. But that just and maybe that's worth digging into on future podcasts, because it just seems like the industry itself is being very disrupted by these legislative fiat type acts.
Yeah, there's no doubt that. Yeah, and you're right. That's a whole another podcast there, because there's so many nuances to it, and it goes in so many different directions. You can look at it from the macro side of what it could do to the insurance industry, and you could dig down into things like Rick's talking about, and there's a million of those examples as to where did you contract it, what did it do, what are your damages? You know, did you just get a cough and go right back to work, or were you in, you know, the ER for several days and couldn't go back to work for several weeks? So there's a million different ways that can play out.
And it probably all will come back to trying to trace back exactly where the root of something like this virus actually happened.
When Rick brought up the workers' comp from a healthcare provider standpoint, since that's probably the majority of our audience, that's really the greatest illustration of the question when this first started is that your workers' comp, you need to be able to show that you got this because of your profession, because you got this at work. Those people on the front lines are going to have the strongest argument that yes, this came because of my occupation, because I was in front of COVID patients for 12, 15 hours a day. And they're going to have a very strong argument for that. And a workers' comp carrier is going to have a very weak argument to say, we can't tell if you got this at work.
Well, gentlemen, I think that this was very interesting and definitely have set up a podcast for a future where we'll maybe focus more on the workman's comp side of this too, as there seems to be some overlap, but some clear distinctions between the two. But thank you very much for sharing your time with us today and these topics. I think we definitely are much more educated than I am than when we began. So thank you very much, and we'll look forward to future podcasts.
Our pleasure, Randy.
Thanks, Randy.
Please consider supporting our mission by becoming an SMA member or making a tax-deductible donation. You can do this by visiting sma.org/donate.